this. So you should get a pop-up on your screen to give your consent to participate in this workshop. So I'll get started. So thanks for coming. I'm Natalie. I'm the Assistant Manager of Student Services at the MSA, and I'm here to welcome Bill. He's our lawyer at the MSA. He is a lawyer in good standing with the Law Society of Ontario. He helps students with a bunch of concerns and things that he can give advice about. So housing, family law, employment, accidents, debt issues, immigration, OSAP, government, criminal, and then anything to start your own business. So thanks again for coming. If you can send me your student number privately in the chat so I can make sure that you're a current student to enter you in the draw, and just make sure that your mic is on mute. And then at the end, if there's any questions, we can address those. So Bill, take it away.
Thank you, Natalie. And yeah, so that was who I am. Natalie explained that well by reading the slide, and that's fine. I thought for a moment I had the same shirt on because they're the same color, but I realized that was a V-neck and this is a round neck. So, but these days are t-shirt days, what can I say? So yes, I am available for any kind of legal advice and assistance, and the list that appeared on that screen that Natalie read is pretty exhaustive, but anything that that a student would like to talk to a lawyer about, there are ultimately limitations on what I can do, but I do all that I can possibly do through the MSA. And if a student isn't, certain whether what they're talking about or what they're doing with is a legal issue, by all means, feel free to touch base with me. I'm not going to be upset and say, oh, that's not a legal issue. I would never do that. I am very happy if I can't help you, try to figure out who else can. If you don't know who else to talk to me. So we can go back then to the second slide, Natalie. Yeah, so we are talking about housing issues today, and traditional self-contained apartments are governed by the legislation is the Residential Tenancies Act, and there is a Landlord and Tenant Board, which is the body, the agency that the government has established to administer that act. And what that means is that it deals with applications that are filed under the act. There are situations that the act doesn't apply to. The main ones being if the landlord shares the washroom or shares the kitchen with the tenant. And sometimes they may share one or the other. There may be an entrance or laundry room. It isn't always absolutely clear whether the situation falls within the act or not. So a good idea is certainly if the landlord shares the washroom or shares the kitchen, the act probably doesn't apply. But there can be gray situations, and only the Landlord and Tenant Board makes a final decision as to whether the act applies and their jurisdiction applies or not. Now, if a situation is not covered by the act, that doesn't mean that's a bad thing. It simply means to be aware that the protections, the rights and protections that are provided by the Residential Tenancies Act, it simply means that they don't apply, but regular contract law still does. So it is still wise to have a written lease, a written document, and it's just that you go by that. So make sure everything that you think is important is in that document, rather than hoping to be able to rely upon the act and the board. And with that, we can go on to the next slide. So what's also good is that for situations that the act does apply to, Ontario now has a standard form of lease. And that is only as of April 2018, because for years, and I've been doing what I do for students at Mohawk and elsewhere for many years, and I can tell you that I've seen leases drafted by landlords, occasionally drafted by tenants, or sometimes no written lease, and they are, as one would expect, all over the map in terms of what they provide for, things that are legal or illegal, things that are understandable or not understandable, not logical in some cases. So the government took it upon itself to create the new standard form of lease that went into effect in April of 2018. And it doesn't, so anyone who has an existing lease that they had prior to that time, that lease is still in effect, but any new lease, a tenant has the right to require that it be on the new standard form. Now, the new standard form cannot be used for the situations that the Act doesn't apply to. As I said, therefore, it can't be used for situations, for example, where the landlord shares the washroom or kitchen. However, it might still be wise to refer to the standard form of lease in drafting a lease for a situation that the Act does not cover, because many of the same topics that the standard form applies to and covers would be relevant to a situation that the Act does not apply to. So I say that, however, I also encourage any student when they're going to be signing a lease, whether it's one that for a regular tenancy on the standard form or for a situation that the Act doesn't apply to on a separate kind of Word document, either way, by all means be in touch with me first. Let's discuss it. I can be reached easily, even on short notice via email. So I'm by no means trying to make things complicated. If anything, contact me will make things easier if you're about to sign a lease. And let's move on. There are spaces that a tenant may be shown and offered to lease that may be actually illegal. And there are building codes. For example, there are building codes about how high ceilings have to be, the existence of a fan or a window in a washroom, and there are like fire codes, the requirement that there be exits and that there be smoke alarms, that kind of thing. So a unit, just because it's available and even looks okay, there may be reasons why it isn't really a legal renting situation. Like I say, building code situations, fire code situations, zoning. Some areas of city, the city government may have said you're not allowed to rent in, or for example, to rent basement apartments in. There's also a limit of how many tenants may live in any given space. So for all those reasons, a tenancy may be illegal. Now, a student may enter into a lease, again, whether it's one that the Act applies to or not, either way. And they may even live there for a while and then find out that it's not really a legal situation. And if that's the case, well, we can deal with it. I have had, although I do the same thing at multiple schools, in Hamilton in particular, for a Mohawk student, within recent memory, I've been able to have a tenancy terminated because of, I mentioned before, low ceilings. And especially for people who are not especially tall, they may say, well, the ceilings, it's high enough. But if they find that they want to get out of the lease, well, then if we look, pardon me, if we look and we find that the ceiling isn't really of the height that the city requires, then that may not be the reason why the student wanted to get out. It wasn't really the situation, but it was part of a broader situation where it wasn't really a very nice premises. And the low ceilings, well, the student wasn't especially tall. That wasn't really, in her eyes, the worst possible thing, but we were able to use that to get her out of the situation that she wanted to get out of for other reasons. The city came, they said, this isn't a legal place, and the student was able to leave, and I was able to write to the landlord and say, city said it's not legal, sorry. She's out, she doesn't owe you any more rent, have a nice life. So I say that because yes, there can be situations where it's not legal, and we can sometimes have tenancies ended on that basis. And with that, we can move on to the next slide. So what responsibilities a landlord has? Well, the landlord has to maintain the building. Not necessarily everything within the building, but the essential building structure, including the common areas, indoor and outdoor, and utilities provided to the building. Now, many times the landlord is responsible for paying utilities. Sometimes the tenant is responsible for paying them if the tenant has agreed to that. But the landlord still has an obligation to ensure that the connections are present and that the utilities are provided to the building generally so that the tenant has access to those utilities that in some cases they may be asked to pay for. A landlord also essential appliances inside the rental unit. So there are those basic responsibilities, but fundamentally a landlord has the obligation to ensure that a tenant receives what is called quiet enjoyment of the premises. And that doesn't only mean literally quiet in the sense of it not being too noisy. It means quiet in the sense of undisturbed. If there are other reasons why a tenant's occupation is being disturbed, just someone coming around and making a nuisance, or someone excessive smells, or dangerous animals, because again, pets are legal, but certain kinds of animals are not. So if for any of those reasons a tenant is not receiving what they're paying for, then they're not receiving what we broadly define as quiet enjoyment, meaning the full undisturbed enjoyment of the unit that they're paying for. So when I say that the landlord has the obligation to ensure that the tenant receives quiet enjoyment, well, that includes in part the landlord enforcing any legitimate rules to make sure that nobody else is doing these things, like I say, the illegal pets, or certainly noise or noise at the wrong hours, odors of certain kinds. Sometimes there can be a meth lab, so it's up to the landlord to ensure that everybody follows the rules so that the ones who are following the rules get the quiet enjoyment that they're paying for. And with that, we can move on. So the rules that a landlord can make, again, we go back to there are rules that govern tenants, but that govern everyone, such as noise bylaws. And even where people own their own homes, and in an area where everybody owns and no one is renting, the noise bylaws still apply. So certainly because they apply there, they also apply in situations where tenants are renting. And that's not rules that landlords are making or have to make, or should have to be the only ones enforcing, although they also have some responsibility there. It's rules that the city government or the provincial government have made, and that landlords have to abide by, as well as expecting tenants to do so. So, like I say, noise bylaws. The Residential Tenancies Act actually prohibits certain rules. A landlord cannot require post-dated checks. A landlord cannot prohibit legal pets. And again, legal pets. There are illegal pets, animals you're not allowed to keep, but that's not, again, the landlord's rules. That is the city and or the province of Ontario making those rules. So a landlord, though, cannot prohibit illegal pets and cannot prohibit guests or restrict cooking unless, like I say, there's cooking. If you're cooking meth and there's an order to that and it's illegal, that's a different thing. So it just comes back to there are government laws and the landlord has to, in some cases, enforce them or allow others like the police to enforce them. But the landlord themselves only very limited rules. The landlord can impose rules prohibiting smoking, even inside the unit that's being rented, not only in common areas, but also inside a unit, the tenant's exclusive use area. A landlord may make rules about the use of common areas, such as laundry room hours, and or not to like loiter in the lobby, that kind of thing. And a landlord may make a rule that tenants must have tenants insurance. Now, tenants insurance is a good idea anyway, and I intend to come back to it toward the end of the presentation. But a landlord doesn't have to say a tenant has to have that tenant's insurance, but a landlord has the right to say that a tenant must have tenant's insurance. That's one of the few things that actually is at the tenant's discretion. So, yeah, there are those permitted rules that a tenant can make, that a landlord can make, but there aren't really very many, because as I say, there's a lot of rules already made by the government, and there's some rules that the government says a landlord can't make, even if they want to. And with that, we can move forward. So, for a landlord to terminate a lease, a landlord may only terminate if the tenant, is in default, which normally means not paying the rent, or it can mean if the tenant has violated like noise bylaws and is constantly creating a nuisance through noise, or has an illegal pet or an illegal activity. I talked before about like illegal drug activity. So a landlord may terminate if the tenant is in default, any of those kind of violations or not paying the rent. A landlord may also terminate if the landlord or the landlord's immediate family intend to live in the unit, or if the landlord intends to do major renovations. Now, pardon me. When I talk about the landlord or the landlord's immediate family intending to live there, well, landlords do sometimes seek to terminate tenancies for that reason, and they do have to give a tenant 1 month's free rent and also 2 months notice, but subject to those things, they may do so as long as it is for real. As long as the landlord is being sincere in that, a landlord cannot give a tenant notice to say, you must move out because I or my family are going to move in. And then once the tenant is gone, the landlord doesn't move in, he or his family. Instead, they turn around and rent to some other tenant at a higher rent. A landlord can't do that. A landlord can only use the reason of the landlord or the landlord's family living there if it is legitimate, if it is true. And a tenant does have the right to challenge a landlord on that if a landlord says that that's what they're doing and they're not in fact doing it. They're just trying to get the tenant out to bring somebody else in at a higher rent, for example. Likewise, I say about the landlord being able to terminate if the landlord intends to do major renovations. A landlord has the right to say, I'm going to upgrade the unit, so sorry, you must get out. Again, the landlord has the obligation to give notice and the month's free rent, and the landlord then has the right to have the tenant out, but again, provided that they genuinely intend to do major renovations that they cannot do with the tenant living there. And I have seen situations where landlords have given students that notice, and the student has said, well, those renovations really are not that drastic. I could be living here and just not using that part of the rented premises while the landlord has them worked on. If it's like only part of the premises, even if it's the whole premises, like painting or bigger work with walls, or sometimes they work with the electrical system, something that pervades the entire unit, the tenant may still say, well, I can be living in this part while the work's being done in that part, then I can be living in that part while the work's being done in this part. It's not going to be done on the same day anyway. So a tenant can likewise challenge a landlord and say, I don't have to move out for you to do these renovations. They're not so major that they can't be done with me living here. And as you can imagine, work of any kind of nature on any kind of premises, there's all kinds of work that can be done. I mentioned some examples, and there's all kinds of things that a landlord might have to do. Flooring, plumbing, there's so many different things. The smoke alarm system. And so every situation is different, and there are no hard and fast rules. Like there's no list that, well, here's the list that constitutes major renovations for which a landlord may require a tenant to leave. Here's the list of renovations that a tenant does not have to leave. It isn't possible to make those lists because every situation is so different. It is up to the landlord to act in good faith and only give a notice of termination if the landlord believes in good faith that the renovations can't be done with the tenant living there. And then it's up to the tenant to accept that or to challenge that. And if the tenant challenges it, it may end up before the landlord and tenant board, who would be the ones to decide that, yes, on the balance of all the evidence that's been presented, the landlord needs the tenant out, or no, the landlord does not need the tenant out, and the landlord will have to do the work while allowing the tenant to live there. It may ultimately be the landlord and tenant board, because like I say, it is not possible with all the variation of renovations that can be done for there to be these hard and fast lists. All you have to do is refer to, and then you'll know. Situations that are not governed by the Residential Tenancies Act, the landlord has more latitude. And if a landlord in a situation that's not covered by the Act wants to do renovations, it is easier for them to say, well, that for this reason we must terminate. But again, it can be an issue of what is really the situation, what is really fair and all parties acting in good faith, and I can be involved in trying to negotiate that. Again, in terms of a landlord terminating the lease, those are the broad categories. And we can move on, I believe, to a tenant terminating a lease. Well, a tenant may terminate at the end of a fixed term or the end of any other subsequent rental period. Now, let's talk first about the end of a fixed term. Very often when a tenant signs a new lease, it's for a one-year term. And sometimes there may not be a one-year commitment. There may be a shorter commitment, potentially a longer one, or none at all. And if a tenant just signs, well, that they'll live there month by month and pay per month, that's great. They can leave on 60 days notice. That's what the law says about situations that the Act doesn't apply to. But if there is a fixed term, such as a year, then the tenant may only leave on 60 days notice at the end of that year. I do see students sometimes who have signed one-year leases, and then they have heard people talk about, you can leave anytime on 60 days notice. So they think, okay, well, I signed a lease until next September, but in January I decided I want to leave, so I'll just get 60 days notice. Well, no, you can't do that. If you have signed until next September, you are committed until next September. You can, if you signed until September 30th, you may give 60 days notice on or before July 31st that you intend to leave on September 30th. But you can't expect to leave even on 60 days notice anytime prior to the end of that fixed term. So be aware of that. Once the fixed term has elapsed, and then there is no reason to sign another fixed term lease, landlords will sometimes ask you to, or invite you to, or pressure you to. Well, don't, because then you're committing again to that fixed term period, and there's no reason to do that. If a lease that, for example, is for 1 year ending on September 30th rolls around, if the tenant does not choose to move out, hasn't given notice, and the landlord has not had any of the valid reasons to terminate the lease, then the tenant has the right to continue living there on a month-to-month basis and move out at the end of any subsequent month by giving 60 days notice. So that's important to keep in mind in terms of fixed term tenancies and in terms of moving out on 60 days notice. The only other ways that a tenant may terminate a lease is by order of the Landlord and Tenant Board or city inspectors. That's one of the ways. I talked before about having the city inspectors out, for example, because of low ceilings, and they say, sorry, this is not a legal apartment. Or an order of the Landlord and Tenant Board. If a tenant files an application to the board and says, here are all the things that are wrong with where I'm living, and yes, I signed a lease until September 30th, I wanted to move out in January. Well, I know I can't just give 60 days notice, but apply to the Landlord and Tenant Board and say, here are all the things that are wrong with the premises. The Landlord and Tenant Board does have the right to say that even though the lease says it continues until September 30th, we're satisfied that all these problems exist with the premises or with the landlord's conduct, and we, the board, hereby order that this tenancy is terminated January 31st, 2021. The board has the authority to do that on application from a tenant. So there you go. Tenant can terminate if they get the board's order or an order of the city inspectors. Otherwise, they must find someone to take it over, either as a subtenant or an assignee. And they may do that if they find someone to take it over that the landlord has no valid reason to refuse, or if they just get the landlord to agree. If the landlord consents to terminate a tenancy early, that's fine too. You normally won't get a landlord to do that. You won't unless there's a pretty good reason why they feel they have to. And I have had situations where, in fact, this is very common. I always recommend this first. If a tenant is thinking of applying to the Landlord and Tenant Board because of problems with the premises, or sometimes with the landlord's own behavior, but certainly with the premises, I've had the situation where we've put that in writing to the landlord and say, we intend to apply to the Landlord and Tenant Board for an order for early termination. So you as the landlord will end up, having to attend, maybe having to hire a lawyer, maybe having to pay the tenant's costs of attending. So that's all going to go down unless you, the landlord, agree to let the tenant out. Sometimes the landlord will say, fine, if you have evidence of these issues, we know they exist, or we know you may be able to convince the board. So rather than if you're that serious, you're going to go to the Landlord and Tenant Board, fine. We will agree to terminate the lease and let you out. If you have a strong enough case, you may get the landlord to consent without having to go all the way through to get the Landlord and Tenant Board's order. So those are all the ways that a tenant may terminate a lease. And with that, we can thank you. I said before about tenant's insurance. Well, a landlord may require that a tenant have tenant's insurance, but it is wise anyway for a tenant to have tenant's insurance because there are two things that it covers. One is the tenant's own personal property. The other is a liability on the part of the tenant resulting from the tenant's negligence. So first of all, the tenant's personal property, if there is a fire in the building, or if there is a break-in, if there's a flood, in any of those situations, the tenant's personal property, clothing, computers, furniture, any of those things may be lost, destroyed, damaged. The landlord's insurance does not automatically cover that. The landlord is required to have insurance on the building as a whole, but the landlord's insurance does not cover the personal property of the tenant. The personal property of the tenant wouldn't be insured, and the tenant would suffer that loss unless the tenant can show who is responsible for the fire, the flood, or the theft. Sometimes that's possible, often it's not. Or what guards against that is for the tenant to have tenant's insurance. And that is why one major reason why it's a good idea to have that. The other major reason, the other thing that the tenant's insurance covers, as I said, is the tenant's liability resulting from the tenant's own negligence. And a tenant, despite trying to be careful, may leave a stove element on, a pot on the stove that boils over and catches fire, may leave a tap running that causes a flood, may leave some kind of a hazard like water or something on the floor that other tenants slip on and fall and hurt themselves. There are various ways that a tenant may accidentally do damage to premises, their own premises, and even that of others. Obviously, a fire or a flood can extend beyond the tenant's own unit and affect other units. There can end up to be a huge repair bill. And I have helped students who have been hit with huge repair bills because they did those things. And you might say, well, who would ever be so careless? But any of us can accidentally do those things sometimes. So those are the two things that tenant's insurance is for, and the two reasons why tenant's insurance is very wise to have. Does that bring us to the end, Natalie? Oh, it does. Okay. Well, that, I guess, is the end of my comments. The one thing, Natalie, we wanted to do to make sure is to show my email address. Thank you. I knew it was coming. And I don't expect anybody who's been listening, either now or to the recorded version, to remember everything I've said. There isn't going to be any test on it, and I know that there's a lot of other things on students' minds. So the main thing we wanted to do today was to flag the issues so that you are kind of aware that these issues exist and that you can think of, if you get into a living situation or issues arise in a situation where you're already living, oh yeah, the lawyer talked about those things. I don't expect you to remember. So remember the most important thing that you learn today, two things: one, that I exist, and second, that Natalie exists. Okay, sorry, there are now three things. The third thing being my email address. And I'm in touch with email. When we did not have the pandemic going on, I was always at Mohawk on Thursday afternoons into the evening and available by email at other times. Now that all consultations are being conducted via email, at least for the time being, I am reachable by email officially every business day, 5 days a week, unofficially 7 days a week. But we don't advertise that, but the reality is I know that issues continue or sometimes arise on weekends or holidays, and don't hesitate to, don't feel you have to wait to email me on the next business day. I'll get back to you if I can, even on times that are not business days. So yeah, the most important thing maybe is my email address, because if things we talked about today or other things, we talked about, as they're going to say here, all legal issues, feel free to contact me and we can conduct a consultation via email. We can exchange documents that way, or other images, links with information. and all of that. So with that, Natalie, I think I am talked out, subject to any questions.
Yeah, absolutely. If any of you have any questions, you can unmute yourself or put it in the chat. But like Bill said, there's his email. Please reach out to him. He helps many students monthly. If you don't get his email, please visit the Mohawk Students website, which is mohawkstudents.ca. And then there is a legal counseling section, which has Bill's information as well. But if you have no questions or you don't want to ask on here, please reach out to Bill. And like he said, he is always on his email to help students. So thank you, Bill, for
You're welcome. Thank you.
Wonderful information. I'm sure it's useful for students that are renting during this time. And if there's no questions, then we can end the session.
Okay, well, thanks again, everybody, for being here.
Yeah, absolutely. It looks like there's no questions, so we're good.
We're good. Okay, talk to you soon.
Okay, bye, Bill.
All right, bye-bye.